Good morning. Happy Monday. There's a meme, I guess you'd call it, where, like step one, do X. Step two, question mark, question mark, question mark. Step three, profit. That's the argument style that Lane Myers is choosing to use. Now, it might be he's choosing to use that style because there's nothing to put in the question mark area. Or it could be that he can't find the thing that goes in the question mark area. One of the two, but I would suggest to you that the most likely thing is that he is unable to find cases or statutes or anything, legislative intent, anything like that, that supports the proposition that if you are a public employee, therefore you cannot be harassed, or something along those lines. Think of it kind of like a math problem. You have to show your work, right? You can't just say, she's a public employee and therefore the First Amendment. It doesn't work that way. If you read opinions that are published by appellate courts, they don't typically say things that aren't supported by cases. Even though most of the time where you have an appellate decision, it's because there is something that hasn't been determined by prior cases. So they will have to make they'll have to make some statement that isn't supported by the prior cases, but they'll lay a groundwork. They'll say, in this case, they came to this decision. In this case, they came to this decision. And therefore, using that same logic, in our case, we're going to come to this decision, and that's the way it's going to get handled. And you're like, oh, okay, that makes sense. What Lane is doing is Lane is saying she's a public official because she took a loyalty oath, and therefore he can't harass her. And he's not providing any underlying basis for that. So other things that he's done are he's made arguments along the lines of, in court, he made this particular argument that he can call a judge and leave complaint after complaint after complaint, and that's not harassment. And he can call the police and leave complaint after complaint after complaint, and that's not harassment. And he says, and therefore, I can call any public employee and leave complaint after complaint after complaint, and it's not harassment. And that might sound like a promising thing. There are distinctions, though. First of all, the phone number you call for a judge, the one that's published in whatever the judicial schedule is not going to get to the judge. It doesn't go to the judge. The judge isn't there to pick up his phone. That goes to the judge's clerk, the courtroom clerk. So your ability to harass the judge is zero. You can't do it because you can only talk to the judge's clerk. That is a distinction. The police station, in theory, if you're calling the whatever non-emergency line, you're not getting a person. You're getting like one of the receptionists, one of the secretaries, or whatever, who answers the phone. Their job is to answer the phone. You're not getting to a specific person. And remember, it has to be directed, according to the statute, it has to be directed at a specific person. So if you're calling the police station to complain about the police, generally, it's not directed at it. If you're calling the police station intending to get to a specific person, like a detective or something like that, you're probably not going to get to him because, again, there's a secretary, a receptionist in the way. And so it's going to be difficult for the state to prove that you're knowingly harassing someone if you're only talking to a secretary. So I would suggest to you that there's probably other reasons other than what Lane Myers suggests, that public employee therefore can't harass them, there's different reasons why it's not harassment. Another distinction, if you are in fact calling a police officer, he is a public official, not just a public employee. He's a public employee and he's a public official. He has discretion to make arrests or not make arrests. The Supreme Court and various lower courts have all held that police officers are public officials in terms of like First Amendment analysis as far as like defamation laws and things like that are concerned. Judges are also public officials. They're elected. They have discretion to make decisions. So if you're making a statement about a judge, that's going to be like for defamation. That's going to be treated. He's going to have to do the actual malice standard in order to be able to recover on a defamation case. Now, does that apply to harassment? Well, you'd have to find a case where it says public officials are treated differently for terms of harassment. Because you got to remember that there's been more than one public official out there who's been harassed, right? So find a case where a public official was harassed and the person who was arrested or charged with harassment took it up to the Court of Appeals and said, but Your Honor, a different standard does or should apply to them because they're public officials. Now, remember, there is a distinction between public employee and a public official. Public officials are, I'm going to say always public employees, but maybe there's an exception. But generally speaking, a public official is a public employee, but not all public employees are public officials. If you look at the Venn diagram, it's probably a small circle inside of a bigger circle that would be, all public officials are a small subset of public employees. So even if Lane gets to the point where he can show that public officials are treated differently for the purpose of this harassment statute, which he has only been able to allege, he has not been able to show to date, even if he gets that point, he still has the problem of trying to make her into a public official. And I don't think that's a burden that he'll be able to show, because none of the arguments that have been made for her, her phone number's out there publicly. Well, so is every law professor's. Every law professor's phone number, their school phone number was on that website. Are you saying they're all public officials? Every teacher is a public official? The student or the teacher's assistants, are they public officials? I mean, it doesn't make any sense. They don't have discretion. They aren't doing things that are going to affect the public generally. I mean, sure, they're grading papers for their students, but those students have paid to be there. That's a different situation than, like, for example, a judge who's making who can make an order that affects the public at random, at large. Maybe not random, but at large. Or a police officer who could choose to arrest or not arrest someone, whether they want to be arrested or not. So it's that level of discretion that is really key in determining who is a public official. And generally speaking, elected persons are considered to be public officials because they're elected. They're responsible to the electorate. So they get to be criticized by the electorate. That doesn't mean, again, that doesn't mean that just because they're a public official that they're immune to harassment. I haven't seen any case law that suggests that you cannot harass a public official. I haven't seen it. That doesn't mean that Arizona might not make an exception for it, but I haven't seen it, and Lane hasn't shown it. And again, that's the necessary step that Lane is going to have to do. And his little fans just keep ignoring it. I don't intend to educate his fans or make them stop, because obviously, I mean, if you're a Lane Myers fan, you're retarded and there's no helping you. But that's for those of you who aren't aware of what the problem is. The problem is that they make this leap of logic. Step 1, she's a public official. Step 2, question mark, question mark, question mark. Step 3, therefore the First Amendment protects Lane Myers' conduct. and it doesn't compute. It doesn't follow it. It's that whole section in the middle that he's omitting is necessary for him to prevail in the argument. It is a necessary thing that he's going to have to do. And if he doesn't do it at trial, he might end up forfeiting it, because generally speaking, you could only appeal things that you raise at trial. And if he doesn't raise it appropriately, he might not, as far as the Court of Appeals is concerned, he might not have raised it. So it's a tricky situation. And that's number one. Number two is a lot of the Lane Myers supporters seem to think that there's some brotherhood of attorneys out there that are like back each other up for some reason. And there are two kinds of attorneys, generally speaking. There's those who are in the practice of law, where they're going after other attorneys every day. And there's judges who are, generally speaking, attorneys who look at the what the two attorneys are fighting back and forth over and pick between the two of them which argument is best, which set of facts is best, etc. But most attorneys are not judges. Most attorneys are in an oppositional position to other attorneys. We fight each other. Now, that doesn't mean that we're antagonistic to each other all the time, because that is a stupid thing to believe. I mean, this isn't trial by combat. This isn't a situation where attorneys have to hate each other. And quite honestly, good attorneys can get settlements. That's the role of a good attorney, isn't to take everything to trial all the time. It's to be able to understand the position that his client is in, whether his client is the state, whether his client is a defendant in a criminal action, a plaintiff in a civil action, a defendant in the civil action, a petitioner in a dissolution or a probate issue or whatever. I mean, no matter who it is, the attorney's role is to be able to understand the facts and the law, to look at them dispassionately, unemotionally, figure out the relative odds of success, figure out a game plan to get the thing resolved in the best manner possible for the client, and then start executing that. That's the attorney's role, and that's what attorneys do. And sometimes you get more by being nice to opposing counsel than you do by being antagonistic. One of the attorneys I work with, we play good cop, bad cop. And sometimes I'm the good cop, sometimes I'm the bad cop. Same thing for him. If I'm the bad cop, he's the good cop. If he's the good cop, I'm the bad cop. But at the end of the day, what we're doing is we're trying to figure out, by applying force, or not physical force, but applying pressure from the bad cop, trying to be charismatic and convincing with the good cop. We're trying to get a resolution for our client. So there's no loyalty to other attorneys. I mean, I represent attorneys in state bar cases. I have successfully resolved at least four. I have one going right now, so hopefully this one will be 5, knock on wood. But the attorney that I'm representing is my client in this case, so it's not like I'm doing it for free. And then the state bar is represented by an attorney. There's an attorney for the state bar who's looking into this ethical matter and saying, hey, we have an issue here. And I'm saying, no, we don't have an issue. And I'm trying to work with this. And trust me, I am super nice and respectful to that state bar attorney, because, well, I'm scared to death of the state bar, to be honest with you. I'm not scared that any of Lane's idiots are going to go out there and say anything to the state bar. I mean, that's been done. Been down that road a time or two. Earl doxed me and tried to do it. Who's that fat dude? That Felipe Hemming doxed me and tried to, get me in trouble. That Daddy and Master, Dragonfire, something or the other, Chauncey Hollingberry doxed me. Bro, my name and my contact information are out there. I mean, this isn't rocket science. I don't really care. I've put it up in a lot of my videos. My name's John Rietveld. My state bar number is 3200086. There you go, dude. You go to the state bar website and you could look up and you could see my contact information there. But the issue is that I don't care, and you're not going to do it. You're not even going to try. And the funny thing is, like, I get people like commenting on my live streams, but there's always a link on my live streams where you can come up and talk, and they don't do it. Isn't that crazy? Isn't that weird? So yeah, that it's the thought that attorneys are in some sort of a mutual relationship with each other is not. We're opponents. We're getting paid to be opponents. Attorneys take it seriously. I mean, hashtag not all. But I've also I've had a couple criminal cases of my own. I've helped out on a few others that I've just kind of done like papers and stuff for. But in those cases, public defenders have a big advantage because they're in front of those judges all the time, and they build up a rapport with the judge, and they use that rapport for the benefit of their clients. The same thing with the prosecutors. Prosecutors spend all their time in front of those judges. They see the same judges all the time, and they use that time with the judge to build rapport. And so they're gonna have a rapport with the judge. That's a good attorney will do that, because they can use that to their advantage for the benefit of their client. And both sides are going to do it. The prosecution's going to do it, and the public defender's going to do it. And they're also going to build a rapport with each other because they're arguing with each other all the time. And it's to their client's benefit not to be an asshole to the other attorney, because they might be able to be like, hey, look, can you just do me a solid on this one? My client X, Y, and Z, can we just get this resolved? Can we get rid of these 5 charges and have my client just plead to this one charge? Can we do that? And because they have that rapport, he's more likely to get that plea deal out of the prosecutor than he otherwise would. I don't think it works the other direction. I don't think the prosecutor is going to be like, hey man, can you just have your client plead to an extra thing? Because the state doesn't have the same kind of investment in it as the defense does. So, but the defense definitely has a desire to have a good rapport with the prosecution, even though they'll fight like cats and dogs in the courtroom. Even though they will, I mean, that's what attorneys do. They will fight like cats and dogs in the courtroom, but they'll also be professional with each other and try to build a rapport for the benefit of their client. And finally, it's just amazing to me that people don't think that attorneys are competent to understand the law, and they think that they understand the law better than attorneys do. You have to remember that every Supreme Court justice is an attorney. They've been licensed in some, they've gone to law school, they've done the thing. They're attorneys. Courts of appeal are going to, every Supreme Court, I don't know of any Supreme Court that has non-attorneys in their Supreme Court. I mean, I guess it's technically possible, but I don't think that would be the case. So judges are, generally speaking, going to be attorneys. And there might be some lower level judges who don't, justice of the peace or something like that, who aren't attorneys. But generally speaking, judges who are looking at serious matters are going to be attorneys. Justices of the appellate courts and Supreme Courts are going to be attorneys. It's attorneys who understand the law. It's attorneys who interpret the law. The judges are attorneys. They're interpreting the law. There's a reason why all of these things go this route. It's the law is like this animal that lawyers have built through cases. Most politicians are lawyers. They write statutes. These lawyers are just part and parcel of the legal system. And you're going to say, well, you're just saying that because you're a lawyer. Well, no, I mean, like all the way back to Marbury versus Madison, the executive branch was we interpret the law. The legislative, because we have to enforce it. The legislative branch was no, we interpret the law because we write it. We know what it means. And the judicial branch was like, actually, no, guys, we interpret the law because we're the judiciary. And in order to determine whether or not the law has been violated, we have to interpret it. In order to know whether the law has been violated, we have to interpret it. So it's our job. So and that tradition stretches back through common law into English common law, etc. So the judiciary has always interpreted the law. The judiciary understands the law. Because remember, it's the Supreme Court's understanding of, in your particular state or in the federal, it's their understanding that frames the issue. It's their understanding that says what the First Amendment is and means and does. It's their understanding. So the Supreme Court's understanding, then your state Supreme Court's understanding, until you get down into your state court, you're looking up the line up to your state Supreme Court and then over to the United States Supreme Court. You might dabble over in some federal cases, but the actual line of progression is that up to your state Supreme Court and then over to the United States Supreme Court that determines what the First Amendment means. It doesn't mean what's written on the page. It means what those lawyers sitting as justices have said it means. And if you don't understand that, or if you refuse to believe it, you're in for a bit of a shock, because when you get into a court, you're dealing with someone who understands it from the framework of, I have to do what those guys above me did. I have to understand this law, this amendment, this Constitution, the way the guys above me did. I have to apply it like the guys above me did. And they're attorneys, and I'm an attorney. And the people who are arguing the case in front of me are probably going to be attorneys. And if they're pro se and they're just saying, no, it means this because it says this, the judge is going to be like, well, that's a great story, and I've listened to you, and thank you for telling me that, but now I'm going to go ahead and rule against you. And it's not because the judge is biased or stupid or whatever. It's because the judge has to do what the justices above him did and what they said to do, and interpret the law how those guys did. And if he deviates from it, then his decision can get overturned because he deviated from what the guys above him did. Because remember, if he doesn't do what the guys above him did, then the side that gets shafted by it can appeal it, and it's going to go up to the guys above him. And they're going to be like, wait, we said to do it this way. I'm going to send it back down to that lower court with the instructions, the specific instructions to do it the way we said to do it. So if you don't understand that, well, it's an expert field. If you don't understand that, or if you think I'm wrong, well, that's great, but your opinion is really meaningless. Like, I get it. You're emotionally invested in Lane Myers, and that's fine. I endorse you being emotionally invested in it. But the law means what lawyers have said it means. And there's nothing you could do to change that. Unless you break down the government in its entirety, remove the judiciary from the state level and from the federal level. Unless you do that, you're stuck with lawyers interpreting the law and understanding the law. That's just the way it is. Thanks for watching. Have a great day.